fact that she son, which obviously would be a marital privilege as well. They would say maybe into that. But the other matter certainly clearly is in violation of what you've already previously ruled, and it's still inadmissible. There's no basis upon which to admit it at this point.
Well, Young, this is a totally different circumstance. This is the mitigation, aggravating phase of the case, and it will also open up a window at what happened, the mitigation, what happened to your life that also led you to be charged, to be facing these charges. The things that you previously, ruled they couldn't be admissible is now relevant because the jury can look into and say, well, we didn't know this. Tony didn't jump on James before. He didn't jump on this lady. Even one. And it will get them a full. She'll go back to March 22nd. She will show the jury, well, on March 22nd, we can understand why Mr. Hood was shooting out of fear. What happened? We just gave them a little bit. We didn't give them the whole thing.
You do intend to try to bring in some evidence about what happened in 1980?
I mean, well, what that is, Judge, when he said he never had no problem with his family until this happened. He's been having problems with it. He's been beating them, matter of fact. That's the rebuttal statement that he made that prior to this incident, he never had no arguments with his family. That's relevant right there. Okay, what? I would also argue fussing my family member for no reason at all. When before, this would have never happened. Yeah, you've been arguing, you didn't beat Coach Tony. You didn't beat him, and she will rebut him on that. Yeah, that's totally contradicted what he said in his Victim Impact, what he told the people yesterday. And it clearly said, you look at the record, I would also argue and fuss at my family member for no reason at all. When before, this would have never happened. That's the ball, Judge. You've been beaten for him. You've been doing it. In that regard, right there is relevant as for that issue. And also said, Jerry Johnson, he tried to take away that evil statue. He is adored by his wife, his son, his family, and his community. Nah, his whole family's on the door. Miss Aileen Howard is his stepmom. That's part of his family. He's not the door. She will rebut both of them. And she will also show the jury, hey, I think the history of Tony had with Jamie called Buddy Christian in life. They need to hear that. They didn't hear it. And she said it. This is not your innocent, this is mitigation. And I keep saying that Tony think you played a role in all the Christian living life. She can see what I'm talking about. This guy cares. Well, she was on hothead. I didn't even get that far. Tony's a hothead. Never got it, Judge. He's a hothead. He don't follow protocol. I do what I want to do. And it's relevant as far as mitigation. Mitigation is things that happen in people's life that the jury can see, hey, this is probably what happened here. Jamie don't need to die. We don't need to kill him because we see what we're supposed to be. He's just not nice. If it's pleading court, what I got the CD. You want to hear it for yourself before you make an admission on it? I mean,
Got a CD of what?
If it's Aileen Bishop House, I didn't play a lot of it because I was trying to, get it through. But this is a new face, and he know what it is. That's why he objected because he's still trying to hide.
When is that? That's in May of 13 or something.
Yeah. But she talking about it, and then the point she said, well, it could have been Jamie. She didn't unequivocally say that. When Tony was bragging at the shop like jacking up Jamie, we replay that tape, and you can hear what she was talking about Jamie Wood. She referring to Jamie Wood. And them agencies, they didn't hear that the first time. And this mitigation part, it's not guilt innocent. Furthermore, if the state didn't want me to get it through, they should have put on the house of Jerry Johnson with a big impact statement. They didn't want to interject it. It's lawful for me to rebut. They them back. And that's what we're doing.
Anything else, Mr. Long?
Yes, sir, absolutely. Just because mitigation doesn't mean all of a sudden open the door and everything's what comes in. Purpose of mitigation is really what the county. This is just a shotgun approach. I'm not going to try to speak like what he's talking about. But in regard to anything that may have occurred between Ms. Howard and Tony Howard in the 80s, it's not a matter that this defendant ever knew whatsoever prior to 2011 at all. There's not any indication that he ever knew that. And under 24.404D, those specific acts are not at all anyway simply because mitigation doesn't make them misleading. Not anyway admissible to somehow mitigate or offer some mitigation evidence about how that particular act affected him.
How about offers your rebut what Tony Howard said in his,
before I get there, can I respond about the statement about something about she said her husband told her something about Tony getting into an argument with his son. First of all, that'd be a complete violation of marital privilege at all. But that is a good bit of hearsay there in regard to what happened like that. It'd be the same matter, matters that he is not at all in any way like that. Further, that does not in any way rebut about him prior to this. He did not fuss with my family in that regard. That he is implying or indicating in any way that is somehow some rebuttalness. All of a sudden, that opens up the door to bring up matters that were not anything that this particular defendant ever knew or ever were aware of whatsoever prior to March of 2011 at all. That does not reflect that in any way. And as he was talking about how it impacted his life like that. So that is not admissible. Those matters are not, simply because the mitigation don't make it admissible at all whatsoever. Just 1 second.
on the door and tell them we're all transportation within those lines. Tell them to call in 5 minutes.
Bottom line, that is not in any way rebuttal or should be officer admitted at this point to come up with matters to this extent was not at all anything aware of prior to that time. And certainly the probative value of that can be added is substantially outweighed by any prejudice, the prejudice in that matter. I mean, it is absolutely unfair for the victim in this case to offer a victim impact to have a defendant come in and all of a sudden bring in matters that were absolutely inadmissible, particularly privileged matters under 24-5-505, and to be able to bring out matters like that and have her all of a sudden come in here and be able to bring up something that may have happened in the 80s perhaps. And it's absolutely unfair to the victim in this case who's been found to be a fortunate victim by the jury. That is not at all in any way rebut that, and the probative value is certainly well outweighed by any prejudicial effect in this matter. And it should not at all be permitted. This was my motion. I argued that it would actually get back up and keep that problem.
Well, y'all, number one, he should have put him up there with that victim impact statement. He reviewed before he put him up there. He put him up there, and he's saying his stuff, and he knew it wasn't right. And it's rebuttal and it's impeachment. He didn't want to say it. We ain't making this up. So it's rebuttal and it's impeachment on one issue. Then we can get to the issue where Ms. Howard said, I think the history, first she said he had to jack him up, they were bragging about it. Then she said, I think the history Tony had with Jamie called Buddy Christian Life. Now that's what I've been trying to tell folks for years. This is where the provocation comes from. And they need to hear that. It's relevant because this did happen. She know it. She heard him talk about you bragging about it. The jury need to get into all the full context of it. This is a death certificate. This ain't no, well, we gonna hide this. He the one put him up there with that victim impact statement. He should have done his homework before he done it. And I can see if we will make it up to false allegation. He said it right here, and it also rebut Jerry Johnson. You try to take away man, the equal statute who is adored by his wife, his sons, and his family. Everybody want to adore this guy. It's false and misleading. Then you want to get into it, Jerry. You know, he said in the victim statement, the officer looking at him, they staring at him. This officer go, man, what you doing, man? We know you didn't do the right thing. That's why they staring at him. We here for the truth. We ain't here to hide that now. There's his witness. He should have thought about that before he put him up there. And he hadn't said he did correct it yesterday. Like I eat my medicine, he got to eat his.
But anything about what may have happened today doesn't rebut anything that Jerry Johnson said about he's adored by his family. And no way rebuts that whatsoever. And to say these matters about somehow her offering some opinion based on, information that's not available to her. It makes her say, something about, I know why Jamie did this to him. It's no more admissible now in mitigation than it would be otherwise. And it certainly doesn't rebut anything about that. And that's not permissible either. For all of a sudden be able to, he basically called her before and she testified about what she remembered about the conversation in that regard. And he had an opportunity at that time if he wished to, and I believe he did at that time, had a full opportunity to question her further about that in regard to that statement of him indicating what may have been said or what was not said. But to somehow now open the door and all of a sudden we're going to do everything in the book here is terribly unfair to the victim and the victim impact statements they've had. It's in no way in mitigation, particularly when none of those were matters that he was ever aware of like that. It would be particularly statement about the Grant Howard violation of matter of privilege.
Explain that.
statement made by Clarence Howard. Apparently, she's relating to a statement made by Clarence Howard, in their marriage, saying that Clarence told me that he did something to his son. And there's two parts to the marital privilege, and she can't use that marital privilege. She can't just start talking about matters that may have been said during the marriage life. There's two parts to the marital privilege. There are two aspects of that.
Here we go.
Well, under 24.5.505, no party or witness shall be required to testify as to any matter that may incriminate or tend to incriminate such party or matter which will bring to decision. Let me look at it just a little bit further. That may not be correct. One part of it is hers that she can basically refuse to say, but another part is the spouse, where they can basically, where she can't just go revealing everything that's said in there. So there's two parts to that. Let me pull that as I don't have it right here. I thought it was 24.5.505. And of course, 24.5.505A talks about no party or witness shall be required to testify as any matter which may incriminate or tend to incriminate such party or witness, or which shall tend to bring infamy, disgrace, or public contempt upon such party or witness, or any member of such party or witness's family.
Well, that would be up to her to impose that.
That is part of it, yes. But there's another privilege about the marital privilege. Let me pull that up too. Internet access.
Stop, we'll let the jury on out.
Reference that we have, we just get that from the series. There are certain admissions and communications excluded for the evidence on grounds of public policy, including but not limited to the following. 1, communications between husband and wife. That is actually includes that she can't go talk about matters that the husband may have told her. It doesn't all of a sudden allow that. The purpose behind that is stated in Trammell versus United States, 445 U.S. page 40, United States versus Singleton, 260 Federal 3rd, 1295. Marital privilege protects conversation between spouses in order to foster marital harmony. A, your husband and wife shall be confident but shall not be compelled to give evidence in any criminal suit for or against each other. But in addition, in B, the privilege created by A, so by corresponding privileges in paragraph 1, subsection A, code section 501 or A 505 should not apply to any procedure. It goes into the matters there, but what's not there. She's not compellable, but it's evident the husband is protected for making sure that certain communications cannot come out, even if the wife proceeds to do that. I don't like that.
All right. Well, I'm ready.
He didn't say that motion yet. Now, you pick that record. Yeah, this.
So you will do you about that. All right. Now I'm going to allow testimony between the alleged incident between Ms. Howard and Tony Howard. Testimony is to what Clarence Howard may have said would be hearsay. It sounds like to me, and not be listening. I don't think we discussed this time, but I think we did the last time, still the opinion of Ms. Howard regarding Tony Howard's role in the Christian death is not necessary.
Well, how about, do I get to talk about, well, we already talked about it today, so, okay. Well, let me just take a breath. First, neither marital nor spousal applies here because she is not married to Tony Howard. This is his stepmom. That's number one. Also, any privilege the witness have or may have is trumped by my Eighth Amendment right to a fair trial in a death penalty case. Also, neither privilege applies to domestic violence against a stepmother, nor does it apply if Tony or Tony's wife told her. I mean, this is the best
I'm not sure what you're saying. I made my ruling actually.
Okay, I see what you're saying. Your ruling go along with that as far as that.
That's correct.
Okay, so I just can't get that opinion out of them. How about Tony as a hothead? She said Tony's
I'll just take up those objections when they come. That's
okay. So we just
cannot render alternate opinions.
Yeah.
So that is the ruling. We'll break for lunch. Return at 1:15.